Welcome to this, the 9th session of our book club, Reasoned Argument, the Counter to Cancel Culture. Well, you remember that last time we went over the Alien and Sedition Acts and then the responses by Madison and Jefferson in the Virginia and Kentucky resolutions. So following from that and the suggestion of nullification, we're now going to go into a long era in which not only the South, but the Northeast is threatening secession. It's a very unstable time, and a lot of it is triggered by what President Jefferson does in making the Louisiana Purchase. Remember that Adams was pro-British, but had to make a deal with the French. And Jefferson is pro-French, but has to worry and defend against possible threats from the French. So we're beyond, in a way, the kind of neutrality that Washington was famous for. But some of the neutrality part of what he did comes into play in this sense. As a result of his neutrality, we had access for the Westerners to the port of New Orleans, at the time occupied by Spain. But with the purchase from France, right before Spain closes much of the port to Americans, and that triggers a very unstable situation. So our focus is going to be on the geopolitical elements that are occurring and the constitutional crisis that follows from the purchase. And at this point, we're talking 1803, the Supreme Court under John Marshall is in this very year deciding Marbury versus Madison. So what we're focused on is not the court here. We're focused on the political branches. In the first part on Jefferson, and the second part on Henry Clay and what he does to keep the Union together over a long period of time before the Civil War. So let's look at our think points for tonight. The first section is Jefferson's purchase of Louisiana, the geopolitics of a constitutional crisis. And then in the second, we go to Henry Clay, the great compromiser, who mediates among North, South, and West to prevent secession. And in the final section, it is the art of compromise and the art of rhetoric. So now let's turn to the first section, that is Jefferson's purchase of Louisiana, the geopolitics of a constitutional crisis. You have to consider the Louisiana Purchase as pivotal, not only in this period of 1800 to 1860, but well beyond. We know that part in the sense that the country expands greatly. But it's not just Louisiana as a state. You'll see from the map that comes up that we virtually double the size of the country at this point. Now, these aren't all yet states, and that's what triggers the constitutional crisis. But behind it is the geopolitical issue. That is, if the port of New Orleans is closed off and France becomes a threat, the US has to do something. So I've used the term geopolitics. It's a term that's really invented in the 20th century. But it refers to strategy, yes. Dealing with foreign nations, yes. But the geo part is related to geography. It's strategy related to geography. Now, the framers of the Constitution, at least some of them certainly understood this. Washington did, Hamilton did, and others did who had been involved in the war deeply. But also Adams and Jefferson understood the problem. Many of us today don't understand the problem because we've lived in a different climate. That is, since the end of World War II, except for the Russian part and today, the Chinese part of the world, much of the world has been controlled, as it were, by what happens in the United States. We often don't even realize it. But as a friend of mine, a former colleague from Argentina, said more than once, when the United States sneezes, Latin America gets pneumonia. The point is that great powers have an impact on other places. And at the beginning, the US was not a great power. And we were dependent on and looking at very closely the great powers of the time and making sure that we were not in any way negatively affected. So look at the map of 1863. This is after the French and Indian War, that's what it's called in the US, or in the time at the colonies, and the 7 Years' War in Europe. After that war, the settlement in 1763, look at the change. What's happened is that England has protected the colonies by gaining Canada, the part of Canada north of the colonies, and Florida south, in order to be protected in that area. There aren't foreign powers that are threatening from either the north or the south. That is a very geopolitical move of defense that's critically important. But the other aspect of this, and we go back sometime to earlier sessions, is that out of that comes a couple of things. What England does after the war settles is to prevent, or at least order, that American settlers do not go beyond the Alleghenies, that part of the Appalachian Mountains. And that is to prevent a war between the settlers and the Indians. War could be caused by either the Indians or the settlers, but Britain doesn't want any part of that. But that ends up being one of the causes cited in the Declaration of Independence, that part that we didn't go over, and all of the claims against the king for what he has done in violation of the rights of the colonists. But in addition, the taxes, the ones that we've heard, the Sugar Act and the Stamp Act, why do they come at this time? The colonies had not been taxed before in this way. They come about because in order to win the war, England had taken on a lot of debt. And to pay that debt down, they want taxes. And that's where the resistance begins in the colonies to these taxes that they haven't agreed to, even though, of course, they benefited from the results of the French and Indian War. So those geopolitical dimensions are very important. Now, when we go into the Constitutional Convention, realize in thinking about what we'll see later, when there is a notion that we shouldn't have entered into the Constitution because of the deals made regarding the South and slavery. Well, if you look at the geopolitical position at the time, you realize that there is Spain to the south, Spain to the west, and still Britain to the north. What are those with a geopolitical mindset thinking about? There's already talk about even a split off in the Western area in terms of maybe a separate country, maybe aligning with Spain because of the Mississippi River. That concession on the Mississippi might not last, and might not Georgia, South Carolina, might they split and go with Spain in Florida? So these are concerns, and if you look at the map, you can see that this is a real concern, to hold the union, create the union as a real union, a more perfect union, and allow it to continue and defend itself. That's very much in their mindset. Now, Jefferson's purchase of Louisiana creates some real problems. Part of the problem has to do with Jefferson himself and his understanding of the Constitution. That is, his compact theory of the Constitution has consequences that he has difficulty, and he should have difficulty, trying to reconcile. And therefore, what he wanted to do is to propose a constitutional amendment in order to justify the purchase and the question of statehood. That is, in the new territories, to be made into states. Well, there isn't any time for a constitutional amendment. It's a negotiated deal. It's a contract with France. If you're going to do the deal, you got to do the deal right away. There's no doubt about that. From a matter of national defense, he's got to do it. Now, if you watch some of the video that I suggested from the Federalist Society website on the Louisiana Purchase, you'll see a lot of discussion about the actions of Jefferson and some of the actions regarding the other countries, but there isn't really a deep constitutional discussion that goes on in that video, somewhat with John Yoo, but the others not so much. And why? There is a notion on the part of some people that once, quote, you get the Louisiana Purchase, and Jefferson believes he violated the Constitution, then after that point, you're making it up in a certain sense. In other words, we're creating a new Constitution. On the other hand, if you understand the Federalist understanding and explanation of the Constitution, you realize there was no problem with what Jefferson did. That is, the treaty power, later the Supreme Court would confirm this, the treaty power certainly was justified to use to purchase this land. No doubt about that. The bigger question for Jefferson really is, how do you treat the citizens, the inhabitants of this new territory? Are they to be made into states? And on what basis will that occur? So we look now to the Northwest Ordinance, section 14. It is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of compact between the original states and the people and states in the said territory, and forever remain unalterable unless by common consent. Okay, so the Northwest Ordinance is important for many reasons. It is often considered one of the founding documents. It's actually enacted by the Continental Congress in 1787 while the Constitutional Convention is going on. Why? Madison realized that the business about lands in the Constitution and even in the Articles of Confederation had to be supported somehow. And so he was a moving force behind it. And that element is significant in terms of what's going to become the Northwest Territory. And that is going to figure in all being free states, as we'll see, and being bargained off against new slave states that are going to come out of the Louisiana Purchase and ultimately end up in the crisis that we get in the decision of Dred Scott. So further from the Northwest Ordinance, let's read this. There shall be neither slavery nor involuntary servitude in the said territory otherwise than in the punishment of crimes whereof the party shall have been duly convicted. Then it goes on to talk about the return of fugitives from the other states. And that is there before the Constitution. So this backs up as evidence for the statement that Professor Barnett makes in his chapter that I assigned. And I'll read that in just a second. But the point is that the Northwest Ordinance was passed without any real objection, because at this point, as Professor Barnett says, back in 1787, everyone basically figured that slavery would die out. So let's read from Professor Barnett. At the founding, there was a national consensus that slavery was unjust and in conflict with the principles of the Declaration. Though dissenters surely existed, even slaveholders, especially Virginians like Washington, Jefferson, and Madison, agreed they could rationalize a gradualist approach to ending the institution by telling themselves that slavery was an economically inefficient institution that would die on its own. Of course, it didn't. And the reason it didn't, Professor Barnett goes into, is that in 1794, you have the invention of the cotton gin. And all of a sudden, cotton picking using labor becomes much more efficient than it was. So now the attitudes begin to change. And then when you add the deployment of steamboats, which in this country begins with Fulton, 1807 in New York, but soon is used in the lower Mississippi, that changes as well. And all of a sudden, there is a strong, very strong economic interest in the South to maintain slavery, whereas before they were simply arguing for a period of time to adjust. Now it's not about adjustment. It's now about defending slavery to a large extent. So what happens with the Louisiana Purchase? Well, in part, the Northwest Ordinance is taken over and applied to the new states, many of the new states, not necessarily all of them. But the part that's left out is the abolition of slavery or the prevention of slavery in the area. And in fact, Louisiana comes in as a slave state. Now, there is a lot of debate over that. And not only are those in the North opposed to slavery, but in New England in particular, they're opposed to New Orleans. And that really may not have changed over time, because then and still today, New Orleans is known for gambling, prostitution, although it's not what it was back then, at least not overt. And so it's not only that, it's these people are French and Spanish. They're different. They speak different languages. And gee, they have a different legal system. It's not the common law. It's the civil law system. How can we possibly integrate these people into our country? And at that point, that's where the real constitutional issue arises. What about the compact theory? That is, in the Northwest Ordinance, the existing states agreed, not only in the Continental Congress, but that was existing at the time of the Constitution. And one of the first things they do after the Constitution is adopted and Congress is organized is to reenact the Northwest Ordinance. And they did this as part of a deal. That is, Virginia in particular gave up its claims. There were other conflicting claims, but Virginia claimed almost all of the Northwest Ordinance area. And so it was understood that if Virginia gave up its claims, then there would be, and there is a provision in the Northwest Ordinance, that those states, that area would be organized into 3 to 5 states. And that occurred, and it was without slavery. But that became a bargaining off with the Louisiana Purchase. And what happened to the states in that area? And that's what we have to deal with going forward. But look at what is said in Novus Ordo. It puts it very well. Let me read this. Republicans faced a dilemma. Their ideology told them to provide for dividing the Louisiana Territory into states so as to make its settlement attractive. Their theory of the nature of the Union told them to interpret Article 4, Section 3. That's the provision in the Constitution regarding lands and admission of states. Now, it was somewhat ambiguous, and deliberately so, apparently, in the drafting or the redrafting in the Style Committee by Gouverneur Morris. Morris, and maybe some others, were not sure they wanted new territories to necessarily become states and admit citizens, because that would involve a shift of power. The original states would have less power. And of course, in the Northwest Ordinance, there's a provision that the new states in the Northwest Ordinance come in on the same terms and they're equal to the existing states. But all of that was set before the Constitution. Now we're talking about new lands that aren't part of the original involvement of the 13 colonies and the other territory. Now we're talking about territory that's not at all under the ownership of the US at the time of the Constitution. So, continuing. As Morris had intended for it to be interpreted, because otherwise the Union would ultimately consist of more states than had been parties to the original compact, and their theory would be reduced to rubble. They followed the dictates of agrarianism over those of constitutional principles, and when they did so, Federalists reversed themselves and took up the compact among the states doctrine and resistance. Now, it's not as well known that the first threats of secession really come from New England, not from the South. Yes, there is in Jefferson's Kentucky resolution nullification, but he didn't say secession, and one could argue nullification without secession. You could argue obstruction and a standoff. But in New England, when they take this up, there is initially some threat by a couple of the senators from Massachusetts that this calls for secession. But the numbers aren't there at that point. Later, however, there is a conference during the War of 1812. And why? Because the Northeast didn't support that. And there were calls for secession at that point. They settled down, we get through the war, and later we'll see secession quickly coming up again and again. So let's turn now to the question about the large republic versus the small republic. That is to say, Madison, as I noted, was the one who told Jefferson you don't need a constitutional amendment. And Madison should be the one, because he, after all, in the Federalist, was for the large republic. In Federalist 10 and Federalist 51 in particular, and I'll read from the end of Federalist 51, it is no less certain than it is important, notwithstanding the contrary opinions which have been entertained, that the larger the society, provided it lie within a practicable sphere, the more duly capable it will be of self-government. And happily, for the Republican cause, the practicable sphere may be carried to a very great extent by a judicious modification and mixture of the federal principle. Well, that large republic is now causing great challenges, which we'll now address in section 2. Section 2, Henry Clay, the great compromiser, mediates among the North, South, and West in order to prevent secession. Clay served in the federal government in one capacity or another for almost 50 years. And he was in the Senate, the House, Speaker of the House, Secretary of State, ran for president 3 times. He is listed as one of the top 5 greatest US senators ever, and some rate him as number 1. Certainly Lincoln, who modeled himself, who greatly admired Clay, would rate him, certainly at that time, as the greatest. So let's look at the eulogy that I put among the readings for today that Lincoln wrote about Clay, and it'll give you some idea about the man. Throughout that long period, he has constantly been the most loved and most implicitly followed by friends and the most dreaded by opponents of all living American politicians. In all the great questions which have agitated the country, and particularly in those great and fearful crises, the Missouri question, the nullification question, and the late slavery question, as connected with a newly acquired territory involving and endangering the stability of the Union, he has been the leading and most conspicuous part. Clay certainly had power as a politician, but there's more to it than that. So let's continue with another part of that same eulogy. The spell, the long enduring spell with which the souls of men were bound to him is a miracle. Who can compass it? It is probably true. He owed his preeminence to no one quality, but to a fortunate combination of several. He was surpassingly eloquent. But many eloquent men fail utterly, and they are not, as a class, generally successful. His judgment was excellent, but many men of good judgment live and die unnoticed. His will was indomitable, but his quality often secures to its owner nothing better than a character for useless obstinacy. These then were Mr. Clay's leading qualities. No one of them is very uncommon, but all taken together are rarely combined in a single individual. And this is probably the reason why such men as Henry Clay are so rare in the world. What Lincoln is doing in this eulogy is an example of what we referred to before as an epidictic rhetoric, an epidictic argument. He's praising with great praise Clay. And one thing in particular about the second part of this that I read is the establishment of Clay's character. Remember that Aristotle said the ways to persuade include logic, ethos, meaning character, and sentiment or passion. We'll look at that the next time in terms of passion. But here the focus is on character. And so what we're going to do is look at three of his speeches, read again by Spud McDonald. And the first one is on the American system in 1820, but it's an early version. He gives a longer version in 1824, but I've chosen the 1821 precisely because it is shorter. In 1820, he was also the person who created the Missouri Compromise, in which at that point, we have on the screen here a map of the Missouri Compromise and how it actually worked. But Missouri came in as a slave state and Maine came in as a free state because the Senate was split evenly and they wanted to keep it that way. They didn't want to get, the senators didn't want to get balance to either side. The North was attempting to limit slavery and it just didn't have the votes to do it. The House is where Clay works the compromise. In addition to that trade-off of the two states, slavery was barred in the Louisiana Purchase above the line of 36 degrees and 30 minutes, with the exception of Missouri. And in this speech, I want you to listen and think about what is most important in his discussion of the American system.
Since the first colonization of America, the principal direction of the labor and capital of the inhabitants has been to produce raw materials for the consumption or fabrication of foreign nations. We have always had in great abundance the means of subsistence, but we have derived chiefly from other countries our clothes and the instruments of defense. Except during those interruptions of commerce arising from a state of war or from measures adopted for vindicating our commercial rights, we have experienced no very great inconvenience heretofore from this mode of supply. The limited amount of our surplus produce resulting from the smallness of our numbers and the long and arduous convulsions of Europe secured us good markets for the surplus in her ports of those of her colonies. But those convulsions now have ceased, and our population reached nearly 10 millions. A new epoch has arisen, and it becomes us to deliberately contemplate our own actual condition and the relations which are likely to exist between us and the other parts of the world. We duplicate our population in about the term of 25 years. If there be no change in the mode if exerting our industry, we shall duplicate in the same term the amount of our exportable produce. I believe that we are already beginning to experience this want of capacity in Europe to consume our surplus produce. Take the great articles of cotton, tobacco, and breadstuffs. For the latter, we have scarcely any foreign demand. And is there not reason to believe that we have reached, if we have not passed, the maximum of the foreign demand for the other two articles? It appears to me, then, that if we consult our interest merely, we ought to encourage home manufactures. But there were other motives recommending it, of not less importance.
The South is opposed to tariffs. If you're building up manufacturing in the North, what's that going to mean? Maybe it will mean suppression of slavery, or if it comes to some kind of secession, the North will have the resources in order to wage a war if necessary, but that's not what Clay wants.
It is objected that the effect of the encouragement of home manufactures by the proposed tariff will be to diminish the revenue from the customs. Can anyone doubt the irresponsibility of government resting solely on the precarious resource of such a revenue? It is constantly fluctuating. On such a system, the government will not be able to much longer exclusively rely. By the encouragement of home industry, you will lay a basis of internal taxation, when it gets strong, that will be steady and uniform, yielding alike in peace and war. The manufacturing system is not only injurious to agriculture, but, say its opponents, it is injurious also to foreign commerce. I would give to our foreign trade every legitimate encouragement, and extend it wherever it can be extended profitably. Hitherto it had been stimulated too highly by the condition of the world, our own policy acting on that condition. Monuments of the sad effects upon our manufacturers of the fluctuating policy of the councils of the Union in regard to them abound in all parts of the country. Villagers and parts of villages, which sprang up but yesterday in the western country, are perishing and abandoned. In New England, in passing along the highway, one frequently sees large, spacious buildings with the glass broken out of the windows, the shutters hanging in ruinous disorder, cheerless, without any appearance of activity, and surrounded by a solitary gloom. Upon inquiring what they are, you are almost always informed that they were some cotton or other factory, which their proprietors could no longer keep in motion against the overwhelming pressure of foreign competition. Gentlemen ask for facts to show the propriety of protection to our manufacturers. Do they want stronger evidence? Let government commence a systematic but moderate support of this important branch of our industry. Let it announce the fixed purpose that the protection of it against the influence of the measures of foreign governments enters into the scope of our national policy.
So you can see by that last sentence that Clay is also focused on the geopolitical and not wanting to be dependent on foreign countries. So then we go to a second speech in which Clay starts to backtrack. And why? That is, he calls for a reduction in tariffs in 1833.
I have long with pleasure and pride cooperated in the public service with the senator from Massachusetts, and I have found him faithful, enlightened, and patriotic. I have not a particle of doubt as to the pure and elevated motives which actuate him. Under these circumstances, it gives me deep and lasting regret to find myself compelled to differ from him as to a measure involving vital interests and perhaps the safety of the Union. On the other hand, I derive great consolation from finding myself on this occasion in the midst of friends with whom I have long acted in peace and in war, and especially with the honorable senator from Maine, with whom I had the happiness to unite in a memorable instance. It was in this very chamber, that senator presiding in the committee of the Senate, and I in committee of 24 of the House of Representatives, on a Sabbath day, that the terms were adjusted by which the compromise of the Missouri question was effected. Then the dark clouds that hung over our beloved country were dispersed, and now the thunders from others not less threatening, and which have been longer accumulating, will, I hope, roll over us harmless and without injury. The senator from Massachusetts objects to the bill under consideration on various grounds. He argues that it imposes unjustifiable restraints on the power of future legislation, that it abandons the protective policy, and that the details of the bill are practically defective. He does not object to the gradual but very inconsiderable reduction of duties which is made prior to 1842. To that he could not object, because it is a species of prospective provision, as he admits, in conformity with numerous precedents on our statute book. He does not object so much to the state of the proposed law to 1842 during a period of 9 years, but throwing himself forward to the termination of that period, he contends that Congress will then find itself under inconvenient shackles imposed by our indiscretion. In the first place, I would remark that the bill contains no obligatory pledges. It could make none, none are attempted. The power over the subject is in the Constitution, put there by those who formed it, and liable to be taken out only by an amendment of the instrument. The next Congress, and every succeeding Congress, will undoubtedly have the power to repeal the law whenever they may think proper. Whether they will exercise it or not will depend upon a sound discretion applied to the state of the whole country and estimating fairly the consequences of the repeal, both upon the general harmony and the common interests. Then the bill is founded with a spirit of compromise. Now, in all compromises, there must be mutual concessions. The friends of free trade insist that duties should be laid in reference to revenue alone. The friends of American industry say that another, if not paramount object in laying them should be to diminish the consumption of foreign and increase that of domestic products. On this point, the parties divide, and between these two opposite opinions a reconciliation is to be effected, if it can be accomplished. The bill assumes as a basis adequate protection for 9 years and less beyond that term. The friends of protection say to their opponents, "We are willing to take a lease of 9 years, with the long chapter of accidents beyond that period, including the chance of war, the restoration of concord, and along with it a conviction common to all of the utility of protection. And in consideration of it, if in 1842 none of these contingencies shall have been realized, we are willing to submit, as long as Congress may think proper, to a maximum rate of 20 per centum, with the power of discrimination below it, cash duties, home evaluations, and a liberal list of free articles for the benefit of the manufacturing interest. To these conditions, the opponents of protection are ready to accede. The measure is what it professes to be, a compromise."
In the election of 1832, Clay ran for president, and that was against Andrew Jackson, who had won in 1828. And Jackson beats Clay, but Clay is still in the House, and he's got to deal with Jackson, and he really is opposed to Jackson. But listen to what he now says in backing off of what he has already been responsible for, the tariffs.
Mr. President, I want to be perfectly understood as to the motives which have prompted me to offer this measure. I repeat what I said on the introduction of it, that they are first, to preserve the manufacturing interest, and secondly, to quiet the country. I believe the American system to be in the greatest danger, and I believe it can be placed on a better and safer foundation at this session than at the next. I heard with surprise my friend from Massachusetts say that nothing had occurred within the last 6 months to increase its hazard. I entreat him to review that opinion. Is it correct? Is the issue of numerous elections, including that of the highest officer of the government, nothing? Is the explicit recommendation of that officer in his message at the opening of the session, sustained as he is by a recent triumphant election, nothing? Is his declaration in his proclamation that the burdens of the South ought to be relieved nothing? Is the introduction of a bill into the House of Representatives during this session, sanctioned by the head of the Treasury and the administration, prostrating the greater part of manufacturers of the country, nothing? Are the increasing discontents nothing? Is the tendency of recent events to unite the whole South nothing? What have we not witnessed in this chamber? Friends of the administration bursting all the ties which seemed indissolubly to unite them to its chief, and, with few exceptions south of the Potomac, opposing and vehemently opposing a favorite measure of that administration, which 3 short months ago they contributed to establish? Let us not deceive ourselves. Now is the time to adjust the question in a manner satisfactory to both sides. Put it off until the next session, and the alternative may and probably then would be a speedy and ruinous reduction of the tariff or a civil war with the entire South. I have been represented as the father of this system, and I am charged with an unnatural abandonment of my own offspring. I have indeed cherished it with parental fondness, and my affection is undiminished. But in what condition do I find this child? It is in the hands of the Philistines, who would strangle it. I fly to its rescue, to snatch it from their custody, and to place it on a bed of security and repose for 9 years, where it may grow and strengthen and become acceptable to the whole people. I behold a torch about being applied to a favorite edifice, and I would save it, if possible, before it is wrapped in flames, or at least preserve the precious furniture which it contains.
This last piece from Henry Clay relates to the Compromise of 1850, again on slavery. Senator Calhoun is opposed to this compromise. The compromise is worked out, and it involves several elements to it, including that California comes in as a free state, and that 2 states that will become states, but they're in the territory to the west, are Utah and New Mexico, and it is left to them to decide whether they come in as slave or free. So we go from there into the speech, his last speech. This is 1850. He dies in 1852. He's not in good health at the time of the speech.
It has been objected against this measure that it is a compromise. It has been said that it is a compromise of principle, or of a principle. Mr. President, what is a compromise? It is a work of mutual concession, an agreement in which there are reciprocal stipulations, a work in which, for the sake of peace and concord, one party abates its extreme demands in consideration of an abatement of extreme demands by the other party. It is a measure of mutual concession, a measure of mutual sacrifice. Undoubtedly, Mr. President, in all such measures of compromise, one party would be very glad to get all he wants, and reject what he does not desire, but which the other party wants. But when he comes to reflect that, from the nature of the government and its operations, and from those with whom he is dealing, it is necessary upon his part, in order to secure what he wants, to grant something to the other side. He should be reconciled to the concession which he has made in consequence of the concession which he is to receive. If there is no great principle involved, such as a violation of the Constitution of the United States. I admit that such a compromise as that ought never to be sanctioned or adopted. But I now call upon any senator in his place to point out from the beginning to the end, from California to New Mexico, a solitary provision in this bill which is violative of the Constitution of the United States.
He says that there is no great principle involved. There's no violation of the Constitution. Are those the only principles? Let's continue with this speech.
The responsibility of this great measure passes from the hands of the committee and from my hands. They know, and I know, that it is an awful and tremendous responsibility. I hope that you will meet it with a just conception and a true appreciation of its magnitude and the magnitude of the consequences that may ensue from your decision one way or the other. The alternatives, I fear, which the measure presents are concord and increased discord. I believe from the bottom of my soul that the measure is the reunion of this union. I believe it is the dove of peace, which, taking its aerial flight from the dome of the Capitol, carries the glad tidings of assured peace and restored harmony to all the remotest extremities of this distracted land. I believe that it will be attended with all these beneficent effects. And now, let us discard all resentment, all passions, all petty jealousies, all personal desires, all love of place, all hankerings after the gilded crumbs which fall from the table of power. Let us forget popular fears, from whatever quarter they may spring. Let us go to the limpid fountain of unadulterated patriotism, and, performing a solemn lustration, return divested of all selfish, sinister, and sordid impurities, and think alone of our God, our country, our consciences, and our glorious union. That union, without which we shall be torn into hostile fragments, and sooner or later become the victims of military despotism or foreign domination.
The fear of the country being torn apart and the possibility of military despotism, I guess, was very real. So how does one, quote, weigh and balance these different considerations? It's not a matter easily addressed.
Let us look to our country and our cause, elevate ourselves to the dignity of pure and disinterested patriots, and save our country from all impending dangers. What if, in the march of this nation to greatness and power, we should be buried beneath the wheels that propel it onward? I call upon all the South. Sir, we have had hard words, bitter thoughts, unpleasant feelings toward each other in the progress of this great measure. Let us forget them. Let us sacrifice these feelings. Let us go to the altar of our country and swear, as the oath was taken of old, that we will stand by her, that we will support her, that we will uphold her Constitution, that we will preserve her Union, and that we will pass this great, comprehensive, and healing system of measures which will hush all the jarring elements and bring peace and tranquility to our homes. Let me, Mr. President, in conclusion, say that the most disastrous consequences would occur, in my opinion, were we to go home doing nothing to satisfy and tranquilize the country upon these great questions. What will be the judgment of mankind? What the judgment of that portion of mankind who are looking upon the progress of this scheme of self-government as being that which holds the highest hopes and expectations of ameliorating the condition of mankind? What will their judgment be? Will not all the monarchs of the old world pronounce our glorious republic a disgraceful failure? Will you go home and leave all in disorder and confusion, all unsettled, all open? The contentions and agitations of the past will be increased and augmented by the agitations resulting from our neglect to decide them. Sir, we shall stand condemned by all human judgment below, and of that above it is not for me to speak. We shall stand condemned in our own consciences, by our own constituents, and by our own country. The measure may be defeated. I've been aware that its passage for many days was not absolutely certain. But if defeated, it will be a triumph of ultraism and impracticability, a triumph of a most extraordinary conjunction of extremes, a victory won by abolitionism, a victory achieved by free soilism, a victory of discord and agitation over peace and tranquility. And I pray to Almighty God that it may not, in consequence of the inauspicious result, lead to the most unhappy and disastrous consequences to our beloved country.
A very strong close, which is always important in terms of persuasion. But it leaves us looking backward to wonder whether he made the right judgment or not. Certainly, it staved off the conflict for another 10 years, but should it have been engaged in earlier? There's no way for us to know whether that would have been any better. In this, the third section, we're going to look at the art of compromise and the art of rhetoric. So first of all, let's note that Frederick Douglass, the great abolitionist, from whom we'll hear 2 sessions from now, he opposed the Compromise of 1850. Not really a surprise. Calhoun, as I already said, he opposed it. Maybe that was a surprise. But if you're Clay or somebody else in the middle, you say, well, wait a minute, those are the 2 extremes, and if they're both unhappy, it must be a good compromise. Well, maybe. Let's look at some of the arguments here. On the one hand, Frederick Douglass is saying, well, you know, you claim that you did this wonderful thing by getting California as a free state. Well, California had already voted to be a free state, is what he says. But even though California voted for it, the Congress has to accept it. What's really critical here is that beginning in 1850, the balance is no longer balanced. That is, with California and the next 2 before the Civil War, you've got a balance that favors the North, the free states. And going forward, when we get into the war itself, it's not just free states that stick with the Union. A number of slave states stick with the Union. So one could argue that the results are effective. You might say that Clay's system, the American system, helped build up the free states. And now that they were getting more powerful, it may be that those states that were slave understand that the way the direction is going. And it may be that war is declared because the South, the slave states, can see that the balance of power is shifting against them. But is there another way to look at this? And that's what we want to explore. That is, that's the art of compromise. What's the compromise built on? So what I want to turn to is a criticism from a conservative source, an expert on rhetoric, long dead now, and that is Richard Weaver. Weaver taught at the University of Chicago, and I happen to have been a Weaver Fellow, along with 2 of my daughters, for the Institute for Intercollegiate Studies. And they promote both Weaver and Edmund Burke. And so I'm turning really to the chapter 3 in the Ethics of Rhetoric on Edmund Burke and the argument from circumstance. Now, Weaver is quite critical of Burke in a way that many Burke scholars and others, I know because I talked to them, they would reject the criticism as aimed at Burke. Putting that to one side, I think the arguments that Weaver is making as applicable to some of the compromisers are actually important to consider. And so in a way, we have conservatives debating conservatives on this issue. But I think you'll recognize that some of the points that Weaver made in the 1950s have a resonance to them today. So let me turn to the work of Weaver, and I'll read some of this. The American Whig Party, quote, never had a set of principles. Lineal descendants of the old Federalists, the American Whigs were simply the party of opposition to that militant democracy which received its most aggressive leadership from Andrew Jackson. Now, in the next assignment with Professor Barnett, he's going to go into this whole business about how the democratic argument comes up at this point. But back to text. It was generally speaking the party of the, quote, best people. That is to say, the people who show the greatest respect for industry and integrity. Well, that's good. The people in whose eyes Jackson was, quote, the wicked man and vulgar hero. That has a certain resonance today, too. Yet because it had no philosophic position, it was bound to take its positions from that of the other party. This is a real problem for conservatives today. They accept the assumptions of the left and try to argue against them. They're always tending to be on the defensive rather than on the offensive. Back to text. It pinned its hopes for victory on brilliant personalities rather than on dialectically secure positions. Clay, Webster, and Calhoun, between them, represented the best statesmanship of the generation, were among the leaders, but none of them ever reached the White House. The beau ideal of the party was Clay, whose title, The Great Compromiser, seems to mark him as the archetypal Whig. Now, the title of the chapter about the argument from circumstance is important. It's not that the argument from circumstance is necessarily wrong. It's not. The question is, what is the range of argument? That is one's argument only about circumstances? Let's talk a little bit or read a little bit more about what the argument from circumstance actually is. So now Weaver is talking about the basic issue regarding always using the argument from circumstance. But the reasoner reveals his philosophic position by the source of argument which appears most often in his major premise, because the major premise tells us how he is thinking about the world. In other words, the rhetorical content of the major premise, which the speaker habitually uses, is the key to his primary view of existence. One of the things the left is good at doing is to tell you exactly where they're coming from, and the right tends to respond to it. Not so much libertarians. Libertarians have their premises fairly stated, but social conservatives and others. So for instance, social conservatives, they talk about on the issue of, quote, gay marriage, they say gay marriage. Well, you've accepted the terms of debate of the other side and you've lost. That's why. Or they say traditional marriage. If you say that, what you're admitting is there is more than one kind of marriage, because traditional is a modifier. If it's a modifier, it limits it. Back to text. The argument from circumstance is, as the name suggests, the nearest of all arguments to pure expediency. Okay, but expediency can be good. And remember, Aristotle said that that is the proper function of a legislative body. It is to decide what is expedient in terms of policy. Well, yes, but that doesn't mean that that's your only argument, or that you never resort back to principle. Again, back to text. Argument from circumstance attempts only an estimate of current conditions or pressures, by thus making present circumstances the overbearing consideration. It keeps from sight the nexus of cause and effect. Cause and effect is critical to moral reasoning, and much of that is simply absent both in law schools and in general argument in the public square and in courtrooms. Back to text. It is the least philosophical of all the sources of argument, since theoretically it stops at the level of perception of fact. In debate, outside of the courtroom at least, when one doesn't challenge the premises of the other side, your chances of winning the debate go down greatly. In court, it's a different matter in the sense that forensic argument is different from deliberative argument. And I've made a point from the beginning of this to focus more on deliberative argument, which very few lawyers are trained in, as opposed to forensic argument, in which they get fairly good training. Ultimately, it's going to come down to this kind of a question. Are you only letting the left move the agenda constantly to the left so that the midpoint is always the one that the conservative takes and is moving just more slowly to the left? And that you can see actually happens on the court or in the courts as well. The problem for law students in particular is that they're immersed into, quote, thinking like a lawyer. But what you may not realize is that thinking like a lawyer in many law schools is about, quote, policy. But policy is expediency, and it has a place in legislative bodies. It doesn't have a place in courts. But when you get habituated only to making that kind of argument, over time, you internalize it. And of course, often for lawyers, members of the Federalist Society who are originalists and everything else when it comes to court, you put them in a political position and they're lost. They don't know what to do. They don't have their bearings. It's very evident in the last several Republican administrations. So this business of rhetoric, grounded in certain types of arguments, I consider extremely important. For next week, you can read the rest of chapter 4 from Professor Barnett's Our Republican Constitution. It's not that many pages. In addition, on the event page of the Federalist Society, we'll have some selections about and from Webster and Calhoun, the two who are the other members of the great triumvirate of this period of time in US congressional history. And finally, there will be an article called Why Harvard Destroyed Rhetoric, Killed Rhetoric. Anyway, it originally appeared in the Harvard Alumni Magazine. So I hope you'll be able to join us next week. Thank you and good night.